Hello, Internet world. Welcome to an installment of Sullivan, Michael Sullivan and Associates and Sullivan and Comp, a series of presentations on the coronavirus crisis and how it relates to workers' compensation and employment law. I have with me today the lovely and talented Eric
DeWam.
I've been working with you for years, and I've been saying Wames.
I go by anything you call me. You just call me, I'll come.
How many times have you corrected me?
Maybe 10.
10?
Today.
Yeah. Okay. I can't reasonably be expected to have.
That's okay. I'm the only Eric. It's not like we have 20 mics in the firm. So
if you're listening to this, then this is probably not the first webinar/Zoom presentation that you have that you've heard from us. Since the coronavirus started, we've launched a couple of things. One is a book, and another is a series of webinars. I think this is number 13. Is that right, Eric?
We are on 13.
Yeah, that's a lot. And we have no sign of slowing. I mean, there's some signs that at some point I may shut up, but no definite assurances.
Don't count on it.
But yeah, I mean, it's been really interesting. We've gone in depth on the law, all the employment law stuff that applies, all the federal laws that have passed, how they interact with California law, all the things employers need to do, return to work, workers' compensation, when is it work related? How does it relate with other pathologies? What about site claims? What about when do you provide a claim form? What about temporary disability? And then I actually interviewed Jake Jacobsmeyer, who was in a coma for 3 months a couple of weeks ago. That was really well attended. So I feel like hopefully we are providing a valued service to the community and exposing, this coronavirus thing and how it interacts with the law.
Yeah, I don't think we expected when we started this back in March that we would be here 13 webinars later and still talking about how we deal with COVID-19.
Yeah, I mean, it's a world transformational event. There's just no way around it. I mean, our own law firm, we still have we have 200 people working at home, and all kinds of issues and meetings and experts. And, this is what we do in 2020, that and social unrest.
Yeah. Don't get us to start talking. We'll never shut up.
Yeah, that's just the first 6 months. So we'll see what the next 6 months brings. But anyway, so we also have the book that's out. If you printed it, it'd be about 200 pages. If you're a subscriber to Sullivan and Comp or just a client of the firm, or you're just listening to this, it's on every email that comes off everybody's desks in our firm, a link to it. It's really useful. It's really in depth. We update it every day, and it contains what I think, you said not to say this, Eric, but
oh no, here we go.
Every question there is about coronavirus, whether it be employment law or workers' comp. Now, you may say that you can never capture the answer to every question because you can't conceive of every question.
But we'll try.
It's not an answer to every question, but I don't care. I think it answers every question. It's great. It's really great. I recommend if you're listening and you don't have it, put it on your desktop and use it. It's broken up into sections, really easy to intuit, like where to find the answer to your specific question.
Yeah, I've got a lot of feedback from the fact that, there's a lot of firms that will put stuff out, but at a charge or just for their clients. And the feedback is it's because we give this to everybody. Anybody who logs onto the website, anybody who's on Sullivan on Comp, anybody can access it. And the feedback is a lot of people are using it, and it's making a difference.
I hope so. I'm really proud of it, and we work really hard on it, and I think it's pretty damn good. It's pretty damn good research.
You say so.
Of course, it is. And so anyway, by way of introduction, so I'm the general managing partner of Michael Sullivan and Associates, right? A law firm throughout California with 9 offices. We do predominantly workers' comp, but we branched out quite a bit over the last few years. Immigration, responsibility, wills and trusts, audits, consultation, civil litigation, subrogation. And very significantly, employment and labor law. And Eric is the lead managing partner of our employment labor law section. And he's done a great job. And the section's really taken off. And I'm really proud of you. And I'm really proud of the section. So we've had you on a lot on these webinars. I'm always talking, but you're frequently on as well.
Yeah, you and I compete for the mic all the time. I love it.
Yeah, that's good time. So that's Eric. And then This is also a production of Sullivan on Comp. Sullivan on Comp is a multi-volume treatise, which is a comprehensive study of all of workers' comp law in California. I mean, it's 15 volumes. It's really unreasonably, long.
Because it answers every question.
It is ubiquitous, and I believe it has, with over I think it's at least over 6,000 subscribers, including all the judges. I mean, it really has, I think, become the standard text in workers' comp California. I'm really proud of it. So this production is through Sullivan on Comp. We just released it to everyone in the world just because it's such a significant and important thing. It's coronavirus. Everyone needs to be ready to deal with it. But when I wear my Sullivan on Comp hat, which I'll be doing today, I take off my defense attorney hat and stop advocating aggressively and relentlessly and unreasonably in favor of all employer-related positions. Instead, I try to expose what the issues are and what the different people are thinking about it and what the parameters are, and try to be a little more neutral, just to get it out there, get the basics out there, and get an understanding on everyone's behalf as to what the scope of the issues are and what the law is. Eric, on the other hand, is a rabid, unrelenting, unapologetic defense attorney.
Can't help it. Cynical to the bone. But
yeah.
Fortunately, this topic lends itself to being rather neutral, as neutral as I possibly can be and probably ever have been.
We're just trying to do it right.
Yep.
Employers are just trying to do it right. We just don't want to screw it up. We want to survive, and we want our people to do well.
Yeah, it brings up what we call, first generation questions. So a lot of these are, it's untested in the courts. So it's, kind of best practices of what we, are predicting will happen.
Yeah. So that's it. That's the basic background. We're not going to have any slides. Normally do webinars. This is the second one I think we've done by pure Zoom interview. The first one we with Jake. So you won't be able to have any slides. You won't be able to download any slides for this.
But the material, everything we're going to be talking about today is going to be in the Navigating COVID-19 ebook that's available on sullivanattorneys.com and on SOC.
It is indeed. And what we're doing today is answering frequently asked questions. Now, underlying these questions is a more comprehensive exposition of what the law is, right? And that's in our book, and that's in our past webinars. Yep. But we've realized these questions are piling up, and what we did is the questions I'm going to ask Eric today, and we are talking about employment and labor law stuff today, not workers' comp, are those questions that have been coming at us from our clients and our users and our viewers. And, they say, okay, I understand this is the law, but what about this? What about this? What about this? And there's a lot of real practical questions being asked in real time. And we realize that people need answers. So we don't have time. We try to keep it to an hour, these things to an hour, because really any more than that is it's just ridiculous running off of the mouth by us. There's enough of that. So we're going to try to keep it to an hour. We can't really take questions as we go, but we have picked out those questions that people are asking a lot and we think will help the most for people that are doing things like returning to work, giving leave, giving sick leave, FMLA, OSHA requirements, all the things that fall under the category of employment and labor law. We'll be doing facts for workers' comp another time.
And although we're not doing the answers live, at the end, you can submit questions and we'll take a look at those and we'll respond directly to you if we haven't covered an issue or you have a specific question. Yeah,
we do that with each one of these things. So if you have any questions or comments, if you want to say, I really loved Eric's bow tie, Mike, that black had a real slimming effect, anything like this.
It really does.
Man. Any question, any comment is welcome. We're very likely to respond unless you're unbelievably rude. Even if you're unbelievably rude, we'll probably respond.
We'll still respond, yeah.
Yeah, but so if you have any questions, the email, I think you have it in connection with however you ended up logging onto this Zoom meeting. We have a team of brilliant people that are actually producing these things who know things that I don't think I ever will. So I'm sure you have the connections with the email and the book, and the sullivanattorneys.com is our website. So if you don't otherwise have it, it's all there.
That's where it gets.
Okay. So I'm going to ask you some questions, Eric.
Shoot.
And you're going to educate me and the world.
Do what I can.
I do your best.
Okay.
With medium power comes medium responsibility.
I like to that. I can probably attain that.
Okay, question number one. Just a couple of questions regarding telework. Now, some questions is what's happening a lot these days is that the governor is slowly letting us all go back to work, right?
Yep.
And so like we at the firm, we developed a policy, about what it's like when you go to work. You wear your mask unless you're at your station, the break rooms, the in and out, the elevators. And there's all these things on the published by the state and federal websites, and every employer should have a return to work policy. And then we've also developed policies where people actually get to work at home permanently. We actually found that works for a lot of people.
Yep. And
that we want to do that. I was surprised by that because I was always opposed to it.
Yeah, you're not alone. Many employers talk that way.
I know. It's like, so the world's changing and we're trying to change with it. But a lot of issues come up with regards to return to work. And when you work at home, I guess this is the term you use, Eric. It's called telework.
Telework is the term that's typically used in all the orders that we're receiving and all of the guidance we're getting from EEOC and the Department of Labor. So
that makes it sound like you're working from your telephone, but you're not necessarily. You're working from your computer.
Nope, it's just remote work. That's
called telework.
It's a new term that we're just adopting to be consistent with all of the orders, so we're clear.
Okay.
So it's remote work. Traditionally, remote work. Now we're using telework because we didn't have enough different terms to use, so we thought we'd add another one.
Now we had when this hit, we sent everybody home except for a few people that were just absolutely essential. They had to be on site, and those were the mail clerks that were receiving the mail and scanned it into our paperless system. Right, we just couldn't have them be at home, so we did it. And now we're starting to have some like office managers and so but now people are starting to come back to work under some circumstances. And what I'm wondering is what happens when the government says, okay, go back to work, right? And we have our policies and procedures and it's safe and we feel like we need the person at work. And then the person says, you know what? I don't feel safe. Maybe the government says it's safe. Maybe you put in some procedures, but I don't feel safe. I don't want to die of coronavirus. And I could probably let them work at home, but I would rather have them at work. As an employer, what are my options in terms of someone who doesn't want to come back to work with government restrictions been lifted?
Yeah, it is probably one of the most asked questions we've been getting because we're already in this phased in approach. People are already coming back to work. Restaurants are opening, salons are opening, businesses are opening. And it's the phased in approach we thought of. And what a lot of employers are hearing is, hey, I know we can come back to work, but I've been teleworking this whole time. I really like it. And really, I'm afraid to go back. I'm not sure I'm not going to get it. So you kind of start with first, if the stay-at-home orders for your particular business are lifted, then there is no obligation, just under the orders itself, to require telework. But there's more to it. Is this for a reasonable accommodation? Right?
Can I make them come back to work?
Depends.
The only reason is they don't feel safe.
The only reason is they don't feel safe. There is no obligation. Take out all the ADA and other potential accommodation issues. There is no requirement to offer telework.
So that means like if they would come back to work, I do progressive discipline and I fire them.
If there are no other issues out there that are, and you have to vet this out. If there's no other issues out there, just I'm afraid, then yes. Now,
that's pretty hardcore.
It is. And that's why, what you can do and what you should do are two very different things often. And I think that's the case here. So can you say, hey, I want you back. You've been teleworking all this time. I just want to see you here. We've done you have your masks that we're providing. We make everything clean. We've gone through all the, OSHA requirements to make a safe environment. You're unreasonable. So you should be coming back to work. Can you do that? Yes. Should you do that now? Probably not. You should probably phase that in and have a interactive process, if you will, even if it's not an ADA or a disability issue.
You try and talk them into it, like.
But yeah, you talk them into it.
So when will you feel comfortable? Just kind of like stop. Don't borrow trouble with this.
Yeah, and
it's unfair to other people though if they're like coming back to work and certain people aren't. And I can see people taking advantage of it, or either out of legitimate need or not. Like they got no one to take care of their kids.
Right.
As if there's no one to take care of their kids and they don't want to come back to work for that reason. Well,
that's different. That's it's different because that could fall under the Families First Coronavirus Relief Act, under the expanded family. We're going to get into that, but that is a protected covered leave. If they say, hey, there's no.
That they can get FMLA basically for that.
It's the expanded FMLA.
Mm-hmm.
It's 10 weeks paid.
But what if they run out of it? What if they run out of the FMLA?
Well, then there's also school activities leave on top of it.
So they run out of that. What if they run out of that?
Which is 40, and then if they're out of that, you are not expected after all of that. You're not required to offer telework, but you might come into a position where, hey, they can telework. I still get them as an employee, and they're home taking care of their kids. Or you get into a position where they're like, hey, if you're not going to let me telework, I'm taking my FMLA. I'm gone. And you have to give me this leave, and I won't be here at all. But if I telework, I can work as long as in the house with the kids. Yeah. So those are the kind of balances you need to strike, especially when you take these hard lines, because the reality is when employers are tested with this later, when you're looking back, God forbid there's a lawsuit, what they're really going to be looking at is how reasonable were you, employer? And this environment is different than anything we've ever seen. So, and every person who's going to be evaluating you, employer, is going to know how different this was. And everybody's going to have their own idea of what's reasonable. So everybody's terrified. We're in June.
I'm not terrified.
What's that?
I'm not terrified.
Well, everybody but Mike is terrified.
No. I'm cool as a cucumber.
And that's actually accurate. But you know what I'm saying? I mean, a lot of these employees,
But it could be out of ignorance more than bravery.
I won't touch that and put poll. So.
All right, I get the point. Hey, let me ask you this: what about minimum wage? If you're working at home, does it change your minimum wage?
Yeah. So this is another part that could actually end up with some inequities. People are teleworking, and say you're in a city with because California has its own minimum wage standards depending on the size of the organization. Most cities, at least over a dozen of them, have a higher minimum wage than that. So LA will have a different minimum wage than Berkeley. So where they're working is the minimum wage that applies to that employee. So say an employee at the firm is making the base minimum wage, which they don't, of course, for California. But if they move into Berkeley, they get $2 an hour extra, right? Because that's where their house is. So is there an inequity there? Well, there might be, but that's the minimum wage law. That's the requirement.
It goes where you're actually living.
It follows you. It follows.
So you can take a pay cut or get a raise depending if you're working at home.
Accurate. And then we get into—
What if teleworking is a reasonable accommodation?
You took the words right out of my mouth. Yeah, that's where it becomes difficult, because people are struggling with, hey, is COVID-19 first? Is it a disability? And the answer is it depends on the extent it affects you. Well, say you're 65 and older, or you've undergone chemo and you're more susceptible to it. Do you have to accommodate that if an employee says, hey, I'm at higher risk, my doctor says I should not be coming into work? And the answer is yes.
You have to accommodate that.
If you can, and if you can reasonably accommodate, which would probably be
then business necessity, right? The general rule.
Yeah, and we're going to be in a tougher argument. There is the standard of reasonable accommodation unless it's an undue hardship, right? And a lot of employers are like, oh, it's an undue hardship to telework. And well, now we've been doing this for months, right? So an employer is going to have, and we anticipated this at the beginning, employers are going to have a harder time arguing that it's an undue hardship to telework, especially if the employee has been properly performing teleworking for 2 months or so. So if it's a disability, you can still ask for a medical note, but teleworking is probably going to be that accommodation. And even though over 65 isn't a disability, right? If you get a medical note from a doctor that says they are more susceptible and it is the recommendation of their physician that they work from home, we're in a gray area that I probably wouldn't want to touch. So you probably do want to allow them to telework unless it really is impacting legitimate business needs of the organization. So not an easy answer, but it's what we're going to be grappling with in the months to come.
Yeah. All right. Well, let me ask you this. Can you ask, one question that comes up a lot is, can you ask formerly full-time employees to return to work on a part-time basis? Can you say, I can't really take you back full-time, but I want you to come back or back in the office part-time?
Yeah. So the answer is yes, but with some caveats to that. So if somebody is what we call a non-exempt or hourly employee, typically that's really no problem at all. Lots of businesses are undergoing hardships, especially, restaurant industry, whatever. I mean, there is a change in the viability of organizations. There's no question about it. So can you reduce hours? Can you even reduce pay? Yes. As long as you don't go below the minimum wage of the city they're working in. And if it's an exempt employee, meaning a salaried employee, there's salary minimum requirements. So you cannot fall below the salary minimum requirements to be an exempt employee. And another issue that I've seen happen is people are coming back, but they're shuffling duties around. People that were normally, all managerial, administrative, are starting to do things that aren't really in that exempt status. So you have to be careful about changing duties of people who are exempt, because you might be popping them out of exempt status either because of their pay or because of their new duties, because they're doing, they're not doing more than 50%.
Yeah, so like only, exempt status is something I wrap my head around as an employer too, because it's like they have to actually be a manager of some sort, otherwise they're hourly. And then you put them in on salary, and then they have a relationship sours and they leave, and then all of a sudden, hey, I was hourly the whole time. I should have been, because I'm not a manager. I was doing stuff. So I see what you're saying is you got to watch the shifting job duties. But the bottom line is that employers, they have to deal with the business necessities. They're laying people off, they're furloughing people, bringing back people part-time instead of full-time is okay.
It absolutely is.
Break the wage and hour laws.
You just keep an eye on that, because I really do, I do see the big trend in lawsuits. It already is really, our PAGA claims, which are wage and hour claims. That's really going to be where people are going to be trying to hit employers in litigation. So we have to keep an eye on that.
Yeah, they're everywhere in California.
It's everywhere. Yep.
It's almost impossible to follow all the California laws and statutes and not be subject to one of these lawsuits. It's really pretty rough.
Accurate.
If you're an employer. So how about this? Can an employer require an employee to return to work with a different schedule? Or can they claim to be unable to work and receive EPS sick leave because it's a different schedule than they originally had?
So schedule is a different schedule. It's not an entitlement for an employee. So giving them a different schedule kind of falls in the same category as, less hours. So yes, they can have a different schedule. And if they say, well, okay, this new schedule, I can't do that, so I'm going on sick leave under Families First Coronavirus Relief Act, and the answer is, well, if hours are available to you, employee, no, you don't. Okay. So if you can't do the schedule, you might want to talk to them about, how long is this going to last? Why can't you? Is it because you have to take care of your kids? Then you might be getting into some.
That's a problem. I mean, there was a case last week in workers' comp. It's just a local case, but the woman was offered modified work. She was partially temporarily disabled.
Okay.
And for modified work, she was offered work, but on a different schedule. And then she couldn't take care of her kids, so she couldn't go to work. And the question was, did she decline work offered by the employer such that she wasn't entitled to temporary disability? And it was actually held by the board that the change in schedule mattered and that she did get temporary disability.
She did.
Mm-hmm. Yeah. Now, this is just a local board decision. It's not binding. But
is there other precedent for that?
It's a little different than what you're dealing with on the employment law side.
Yeah. And a lot of times we'll get into a place where what is the result in workers' comp is going to be different under employment law standards or Osha or whatever it might be. That sounds like one of them. And if there's an ongoing workers' comp case, do you give them TD in that situation?
Yeah, so it gets a little bit overlapping.
Yep.
What is the Bp Sla? Just really briefly for our studio audience and stupid people like me that don't remember these acronyms.
So if you haven't been listening to our other webinars, and you haven't,
I was listening.
Oh, you were listening.
I just can't remember it
all. There is the federal law that came out, the Families First Coronavirus Relief Act, which we'll call FFCRA. Below
there
that,
is FMLA expanded, and there is extra sick leave.
That's right.
Yeah.
So the FMLA expanded is the EFMLEA, which is called Expanded Family Medical Leave. Mm. And then there's the EPSLA, LMNOP, which is the expanded paid sick. So that's 80 hours.
So let's call it expanded federal sick leave.
Okay, you can do that. So it's a mandated federal sick leave, which is 80 hours if you fall into one of 6 criteria for that are COVID related. And this is all this new leave that we're talking about it has to be COVID-19 related.
Well, we have this question here that comes up a lot is, can an employer allow employees to use employer provided paid leave benefits provided by the employer concurrently with the federally expanded sick leave, or EFMLA? Okay.
So concurrently is if you have an employer provided benefits, right? That is different than.
Is that like Is that like PTO?
Yeah, it is separate than, and one of the criteria in this new law, the FFCRA, is this is in addition to anything you employer already provide.
Okay.
Not to supplement. So this is in addition to, this is something more than what you employer already provide to your employees.
So you can't use it concurrently, it's an add-on.
It is an add-on. Yeah. And you also can't require them to use employer benefits, whatever the employer is providing, first. It's their election. So you can't say, oh, we'll give you expanded family medical leave, but first you have to use your vacation pay. No, you can't do that. So you have to give them the option to use their FFCRA benefits first, which are paid.
Yeah.
But also, I mean, their tax credits also. So why wouldn't you, employer, want to use that, because you get it back as tax credit.
Okay. And again, folks, if you're listening, then the details under which you can get this expanded leave or sick leave are in our book.
Yep.
This is really specific conditions. What about this? Can employers, how about this? I'm thinking that I would like to have a COVID-free work environment. Okay.
Don't we all?
Like it so that everybody that went in there felt that they were safe. So what I want to do is make all my employees get tested every 2 weeks.
Oh yeah.
Can I do that?
Can you make them get tested every 2 weeks? This is the and the short answer is probably so.
You can.
Probably so. But depending on what that test is, right? We don't have really a test out there that is foolproof, right?
There's two types of tests, as I understand it. There's antibody tests,
right?
If you've had it at some point,
right?
And then there's the test to see if you have it.
COVID never, yeah. And the antibodies test is not one we should be using. It's whether or not. Well, I mean, somebody could have had COVID-19 at some point in time in January, February, March.
Yeah.
Right.
So
you're not going to let your employee back ever if they test positive for?
No. If they have the antibodies stuff, then they're presumably not infectious.
Right.
So if they have the antibodies test,
we don't know that. We don't know that somebody can't get it again.
We don't know that for sure.
We don't know
the problem.
Yep. So
but you got to think it probably is, because that's how viruses work.
Yep. So this is the way.
Not for sure. Yeah.
This is what we're recommending, because there's, everybody's worried. Everybody wants a COVID-free environment, but how often you test somebody, you should probably be putting other measures in first. One is, can you temperature check? Is somebody displaying symptoms? If somebody has
I don't want to do that. I want to do a test.
Okay. Well, one, if you're paying for it, right?
Mm-hmm.
And two, if you're administering it equally to everybody. So every one of your 200 and something employees have to go to a doctor or go to whatever clinic it is, get tested on your dime every 2 weeks to make sure that they don't have it. Arguably, yes. Is that a good policy? I don't think so. But is it something you can do? Probably. I haven't seen any employer try to do that yet.
Well, if you tested everybody, then you would know that nobody had it.
Well, for that moment in time, then they go to Target and then they have it, right? In the 7 days, and they've been at work and they've been infecting everybody.
Does testing involve taking blood?
It's a nasal swab. It's really uncomfortable.
You can do it every day. That's really uncomfortable.
Oh yeah. Well, basically you have a nasal swab jabbed into the back.
They stick it way up in there.
Yeah. So it's not pleasant. It's not pleasant.
Well, I don't see why that's a bad idea, because everyone gets tested, say, every week. Then.
Well, this is the problem you get into, is everybody tested, and you have tons of locations. You have a workforce of 500 employees, and everybody's getting tested every 2 weeks. Administratively, that is going to be a real big challenge.
Well, you can bring them on site. You can bring the testers on site.
You can.
Say, up your nose with a swab. And then if someone won't submit to the test, if you decide on this as a policy, then can that be a subject of progressive discipline?
Yes. If you have it in a written policy, and if the policy is written in a way that doesn't violate any disability or accommodation types of laws, then arguably, yes.
Okay.
Yep. Same as if you had a policy in place where everybody who comes in has, and I know you're not a fan of this idea, but a lot of employers are, and do it. And it's done very widespread right now. You come in and you get the thing on the forehead, and they see if you have a temperature, right? Your written policy is everybody who comes in gets that temperature check. And employees, and that's a written policy, people have signed it. One employee says, I'm tired of getting my temperature check. I'm not going to do it. Well, that's a violation of our policy. And the policy is there for the one criteria that is really overarching all of these new laws is stopping the spread. So employer, I am trying to stop the spread. You are violating the policy. Is it a terminable offense? Potentially. But then we get into, just because you can, doesn't mean you should, right? So have the interactive process. And I know everybody likes bright lines. Okay, you're out. You're not going to get your temperature. Well, what is it about the temperature issue that you have a problem with? Is there a less invasive way? So these, bright line, strict, you're fired if you don't get your temperature checked.
What if they develop a vaccine, and I insist that everyone get a vaccine as a condition of continuing to come back to work?
No.
Why?
because yep, you can look at your notes, but it's still no. You can encourage vaccines like we do for flu. You can encourage it, and if you're encouraging it and offer to pay for it, but can you make it as a mandated term of employment that people get a vaccine? No.
Okay.
Sorry. Yeah, I know. Don't be.
Okay. I mean, I'm just asking. I was asking the question. What if we make them wear face masks? Can we do that?
Yes. All of these, and you really should be looking at the CDC.
As a condition
guidelines.
of employment, they have to wear a face mask?
You can with a couple of caveats. Just really one.
Just can't get a straight answer out of you on anything.
Hey, I'm trying.
This is what I love about employment lawyers.
I'm here for you guys. So the answer is it depends. So can you require a mask as part of your policies? You can. And I actually encourage you to do that, especially now and following the CDC guidelines, which include PPEs, personal protective equipment. If you're requiring it, you have to pay for it, employer, right? So you have to provide all these PPEs, all of this extra equipment to protect the workforce. Now, say there is an employee who has some form of disability where having the mask on their face all the time is actually exacerbating it. It's a disability. It's it could be an asthma or some issue. They get a doctor's note that says they can only wear a mask for, a couple of hours a day or some limitation. You have to engage in the interactive process to try and accommodate that and find ways to achieve the goal, which is stopping the spread.
It's true for anything, though. I mean, anytime someone's got a morbidity that they say is affecting any workplace condition, you always have to have a reasonable accommodation process, right?
Yep, exactly. That's why I said
always a caveat to everything.
It depends. Yep. Sorry.
That's okay.
But the reason I bring it up is it's been coming up.
Yeah.
It's been coming up quite a bit because
I have a deviated septum. I'm allergic to my own carbon monoxide. I have COVID-19, so my lungs don't work as well.
Right.
No, I'm just kidding on that last one. Okay, let's get into Osha.
Oh God. Okay.
So Osha is a federal and state organization which is in charge of the safety of employers, and they oversee employers and require that employers record injuries and incidents, and also that they say they report them to Osha under a whole set of circumstances, which we're not going to get into here. But we do have a section on Osha, believe it or not, in our book on coronavirus. Now, it relates to coronavirus. OSHA is a big deal. They will come in. They will fine you. If you don't fix your unsafe conditions, they will fine you some more. They have agents, and they're not kidding, you know. Remind me of you ever see that Seinfeld episode with the library policeman?
Yes. Oh, God.
Well, let me tell you something, Joy Boy. They take this very seriously, you know. I mean, it's like that. They're not kidding. They're going to give you a hard time. And it's not library books. It's workplace safety, which is serious. Like, people get hurt, and the state wants to know about it, right?
State and Fed, yeah.
How is this relating to COVID? Because, you know, we've had a lot of discussions about when an employer knows that someone has a work-related COVID and when they have to provide a claim form, right? We've had those discussions. What I'm wondering is what does OSHA require of employers when somebody presents with symptoms consistent with COVID or having COVID, whether or not they claim that it came from work, and what does OSHA want you to do there?
So it's complicated, and it should be a lot easier considering that this, you know, affects all employers. But let me give you kind of just a nutshell of what we're looking at. There are two entities. There's OSHA, which is the federal version, and then there's Cal-OSHA. And Cal-OSHA is the California version of regulations. You can find those, you know, one on our book, but also with the Department of Industrial Relations usually has guidance on Cal-OSHA. Now, OSHA is the overarching federal law, and generally, state laws have to be in line with federal OSHA. California, unsurprisingly, has put some stricter requirements on employers. Go figure. So whether they can do it or not is up in the air. But there's been specific guidance from both OSHA and Cal OSHA on specifically COVID-19. And when you have to either, one, record it, which is a form, or two, report it, which is more of a serious injury. So for both, there's kind of, the main criteria that we're struggling with and dealing with is, one, is it a confirmed case of COVID-19? And that's the first criteria that the federal OSHA requires. Cal OSHA has taken that requirement out. They've said, hey, medical resources, they're not available. So we're not going to necessarily require you to have a confirmed test positive case of COVID-19 in your analysis of whether you have to record or report it.
What do you have to have?
Any type of other lost days of work is probably the lowest standard that they put out there. They missed some days of work.
But you could lose some days of work for anything.
Because of COVID-19.
Well, how do you know it's COVID-19?
Well, anytime you hear it is an employee is going to say, I have COVID-19, right?
So when it's identified by the employee as COVID-19, whether or not it's confirmed by testing, then it falls within the category of something that OSHA wants investigated.
Yep. So OSHA normally would say, hey, if you have to report it, they have to tell you.
But if they just have the symptoms, like they have symptoms consistent with COVID-19, but they don't tell you they have COVID-19. They just say, I'm sick and I need to stay home.
Then it's not triggering the OSHA requirement.
Okay, so you have to be at least told that they have COVID-19.
Correct. So say an employee says, I have COVID-19, I need, to go home. So the employer will, you can talk about, what's the workers' comp component, but from the OSHA component, what do you have to do? So now under Cal OSHA, well, I know they have COVID-19, so they've told me. I don't need apparently a test positive. There are missing days at work, right? So now I have to figure out, is it work related? So what the heck does that mean? And what's the standard? So the standard.
So now Cal OSHA is requiring the employer, if someone has COVID, to investigate whether it's work related.
Correct.
Ooh.
It's a reasonable inquiry. And the kinds of things that you have to ask are, hey, do you know how you got it? Do you know how you got COVID-19? And, the employees are going to go, I have no idea. Okay. And you can get into, what we call contact tracing. Where have you been in the last 14 days? Well, I go to Target every day. Who are the people you've been around the last 14 days? Well, and what are their names?
That would include work too, right? Work and non-work.
Right. What people around work have you been around? And you want to ask that question, not just for the inquiry as to whether it's work related, but also for the safety issue for your other employees. You have somebody who has told you they have COVID-19, who has been in the general population, and you have arguably a duty to tell the people that person has been around that they may have been exposed without identifying the person's name or identity. So those are the kinds of questions you have to get into for a reasonable inquiry. And the standard is what we call a preponderance. It's more than 50%, right? So if you are more than 50% sure, you have actual objective evidence that it is work related. 10 other people in the office have COVID-19, right? They've been nowhere else but in the office. They haven't gone anywhere. They go from home. Nobody at home has it. All they are in the office, there's 3 people, 4 people, whatever has it. There's probably more than 50% chance that they have it. Now, what do you do? If they're just going home, all you have to do is record it on a Form 300. And we've been, and the issue is, well, okay, if I put this on a Form 300 and submit it, and am I admitting this is work related? And
that's recording, not reporting, right?
That's reporting, right? And you have to do that within 7 days of when you have this, you've made this determination. So that's recording, and recording it, the DIR has said, does not mean that you admit it's work related. You're saying there's more than a 50% chance it could be work related. That's all. I don't know it, but more than 50, right? And then you get into the more serious injuries. You get a call, I'm in the hospital, they're hospitalized for a week because of COVID-19. Okay, that's more of a serious injury that might require reporting within 8 hours if it is work-related. And you have to go through the same steps of determining whether it's more than 50% chance it's work-related.
Okay, and again, it's all in Sullivan. It's all in our COVID book, folks. All the details, and OSHA is a really in-depth concept, which we can't really cover in totality here. OSHA is the branch of government that you have to deal with. Okay, it's like that. So it's no joke. I mean, you have to know your stuff, and most people probably listening to this out of risk management do know their stuff. But it's interesting to me because, you know, as a work comp practitioner, I'm asked constantly by my clients, when do I have to provide a claim form?
Right.
And what I've been telling them is that under the Honeywell standard, and again, we have a whole hour webinar on this and a whole bunch of writing on this, but in brief summary, an employer only has to provide a claim form. And by the way, when you provide a claim form, you have to start providing medical care, you know, or make it available within 24 hours. If the employer knows and not is reasonably certain, but knows, like knows.
Yep.
Yeah, I've said it many times, but in the Honeywell case, what happened is the wife called the employer and said, my husband is checking into a psychiatric facility, or pushed him over the edge with your head games. And that was found not to be employer knowledge. The employer in that case was found not to have knowledge by the Supreme Court of California. They said reasonable certainty is not enough. So the standard is really high for sufficient knowledge under which the employer has to provide a claim form. Why is that important? Well, employers need to develop policies as to when they're going to give people, let's say, I have COVID-19 a claim form. Are you just going to give everybody a claim form? This is I have COVID-19, because what are they going to do? They're going to fill it out. You know, sometimes knowing what they're doing, sometimes not. And you're going to be just dealing with all these claims, a lot of which have merit and a lot of which don't. And I've also advised that the governor's presumption doesn't have anything to do with the concept of employer knowledge. It's a standard of proof once a claim has been filed. It's not, doesn't have an effect, you know, the standard under which an employer is considered to have knowledge. But now we're doing a very more delicate dance. I understand that the conditions for OSHA that you're describing, Eric, came out on May 19th.
Yep.
And so now they're saying, if you know under a sort of more than 50% standard, then you got to write it down, and it's not an admission that's work related.
Right.
What are the implications for that in terms of your obligation to provide a claim form? It's a little more delicate, but I would say that nothing's really changed. You could say, I mean, the thing that I don't like is I've been telling employers, if someone says that I have COVID, you don't have to investigate, you don't have to ask, right? Just say, okay, go home, take your sick leave. That's it. But now you do have to ask. Right? So if someone says, I have COVID and it's work related, now you have to provide a claim form. So this OSHA requirements creates an environment where at least initial inquiry must be made. Where do you think you got this? And if you run into the assertion that someone got it from work or they want to file a claim because of work related contraction of COVID, then you have to provide a claim form. So, you know, it makes it more dangerous for an employer. But all that being said, the standard under which you may conclude after a reasonable investigation that something is recordable for OSHA is not the same thing as knowing that someone has work-related COVID such that a claim form needs to be provided.
Yeah, I think those standards are
getting pretty edgy, getting pretty.
It is,
hairy.
but those standards are, I think, a world apart. More than 50% is much different than I know it. This person got COVID-19 because they're at work.
Yeah.
So, and I guess the trouble comes, well, I have to ask these questions, right? So, and try and do a reasonable investigation. So what does that look like? Well, you don't, like anything else, you don't ask leading questions, right? Did you get this from work? Well, you don't have to ask that. So the question you ask is, do you know how you got it?
Right.
Do you know how you got it?
Right.
And the answer, you know, if the answer is, I think I got it from work, then you probably have, you know, you might have a problem there. If the answer is, I have no idea. Okay, well, where else have you been?
Mm-hmm.
And have them listed. So I still think, I mean, those standards.
And the governor's standard, like let's say they say, I don't know how I got it. And they say, were you around anyone at work that had it? They say no. Were you around anyone at home that had it? They said no. Now, the governor's issued a presumption. So if they were to file a claim and take it to court, they might actually win that case because there's a presumption that it came from work unless you can prove otherwise where it came from, right?
Which doesn't apply to OSHA.
That doesn't apply until you're in litigation, until you're like fighting about proving it, right? The standard for knowing it, either for OSHA or for filing, giving a claim form, is different than that. The presumption, I think you'll agree, it's irrelevant to this inquiry.
Yeah, and it's specifically the presumption does not change OSHA. It does not apply to OSHA.
Mm-hmm.
So I agree with that.
Absolutely. So it's sort of a subtle and complex set of realities that you need to handle, with a high level of consciousness about what you're doing.
Yep.
And you probably should contact your friendly local lawyer to walk you through this.
Not to say you need us or anything, but but I mean, it's a good idea, even if we didn't have this whole OSHA thing, to do this type of what we're calling contact tracing anyway, not just to make a determination of claim form or form 300 for OSHA, but for the general safety of the organization, right? So just sending somebody home because they said COVID-19, I think they're still under general safety obligations to ask the question, do you know how you got it? Who around the office have you been around? How long were you with them? Were you wearing PPEs? That kind of thing.
Okay.
Yep.
Okay. Well, we've only got like 10 minutes left, so I'm going to move away from OSHA. I'm going to ask you some questions about FMLA. How do you like them apples?
I like it. I like it a lot.
Like it?
I do.
Okay, so we know that every answer you give is qualified, that if there's some issue about reasonable accommodation of some illness or condition, that it has to be made. Okay.
So you don't want me to go there? Is that what you're asking?
Don't keep saying that.
Okay. It depends.
It all depends, okay?
Yep.
And we have to reasonably accommodate people that have disabilities, COVID being possibly one of them.
Right.
Okay, so let me ask you some questions about the FMLA stuff, though. One is, like traditional FMLA, can expanded family leave, that is, the extra family leave you get because of COVID, be unilaterally designated by the employer?
So there isn't.
And by the way, what does that even mean, unilaterally?
Sure. So one thing we do know, and we didn't know when all of these laws came out, what's expanded FMLA? Is that another 12 weeks? Because family medical leave is the federal law, Family Medical Leave Act. That gives employees 12 weeks for a qualifying condition. Usually it's a serious health condition, what we call serious health condition.
Right.
We also have another law in California that's called the California Family Rights Act, CFRA, right? Typically, those run at the same time. They have the same qualifications. The employee has to be, employed for 12 months, worked for 1250 hours, and have a qualifying condition. Now, what is this what's this extra FMLA?
Yeah.
So
is that an add-on or is it concurrent?
We didn't know at first. And then they of course, they amended it saying, oh no, you only get one 12-week period, right? But if it is under the qualification of you have to take care of a child because of school or daycare closure, then it is under the EFMLEA, the Expanded Family Medical Leave Act, and that is paid. So regular FMLA, not paid. Expanded FMLA is paid up to 10 of the 12 weeks, and it's really all 12 because the expanded paid sick leave also covers childcare, and you get the rest of the 2 weeks. So it's just under two different laws. So you end up getting the full paid 12 weeks. The calculation is a little complex. Look at the book.
But can you get the 12 weeks paid and then the 12 weeks unpaid?
What's that?
Can you get the 12 weeks paid?
Right.
And then get 12 weeks unpaid?
Nope. They run concurrent. Yeah.
The only question is whether you're getting paid.
Correct. And there's only one qualifier for the expanded FMLA, and that's to take care of a child, right? School closures, et cetera. Then there's the paid sick leave, which has 6 qualifiers that talk about, you have to take care of somebody that has COVID, you have COVID, and one of them is also you have to take care of a child.
Yeah, so like 12 days of extra sick leave, which you can use first, and it's paid, It's extra from any PTO or PTO-like sick leave stuff.
Yep. And then if you have to document it, and then it becomes tax credits, and the employer, you get it back actually almost immediately. So it's meant to do that. Now, the question becomes there's FMLA and CFRA, as I mentioned. And the trouble is, okay, FMLA and CFRA typically go hand in hand at the same time. Does that the case under the EFMLA? So if somebody takes 12 weeks paid, technically paid, is Cfra also running? Because they also, at the same time, concurrently. And the answer is no. So, and the reason is Cfra does not have a qualifying reason of taking care of your child because of school closure, right? So you don't trigger Cfra when you take that leave. So potentially an employee can have those 12 weeks of EFMLEA and then get another 12 weeks of unpaid leave under Cfra if they have a serious health condition, which could be COVID-19.
COVID, yeah.
Right? So
yeah, this is really complicated.
Yeah.
You have to like consult with your HR professional and lawyer like every single case.
There have been every HR person I've talked to, and they've been in the game for decades, is struggling with this, and they constantly have to call. And the first step is you have to document what you're doing and track it from the very beginning.
Yeah.
Which gets to the question which I'm sorry you asked before: can you unilaterally designate it? And this was the long way around to answer your question. FMLA typically allows the employer to unilaterally designate. Somebody goes out, they have a serious health condition, and you can say, your 12 weeks are running, employee. Your FMLA is running. Here's your notice. We've designated it, and the clock is ticking on 12 weeks. Can you similarly do that for EFMLA? Yes, you can, and you should, to properly document it. You don't want to do that after they've been gone 12 weeks and say, oh, by the way, your FMLA was running. You want to tell them.
We have more time because we have some really interesting questions here.
See, you get us talking, and we could go on forever. We can go on forever, which I think means we'll probably have another another webinar.
I guess so, man. I think we're just about out of time. Let me ask a couple of quick questions that I think are helpful to people. Can an employee require an employee to look for an alternate childcare if their regular child care provider remains closed during the pandemic?
Yeah, no. So as long as an employee says, hey, my child care is closed, and it seems like it would make sense that you say, well, look for another child care, right? The regs have not provided that. Now, they don't specifically say, do not ask that question, but I don't think you want to get into that place without guidance, right? And so you probably should just give them their 12 weeks. Again, it comes back to you, and let it run, as opposed to being that employer that said, oh, they should have found somebody else.
But I can ask. I just can't deny them the benefit.
I guess you could ask.
Possible? Is there a way you could do this? Is that possible for you or not? Or
I think that's reasonable.
I'm going to give you another one. I'm cutting you off because I'm out of time. Can an employer grant the leave to an employee during the summer when his child is out of school for summer vacation?
Well, no, because it's only for if they would have been in school otherwise. If somebody's out for summer vacation, they're not out for school, it qualifies under it. It's the same analysis if somebody is furloughed, right? If they're furloughed, they don't get this either. If they're laid off, they don't get this either because they don't otherwise have work.
Right, because it's all meant to replace work that otherwise would have been happening.
Yep, that's it.
Okay, we're going to have to call it quits.
All right.
Eric, there really is truly, just
endless.
We could do this all day.
We could, and we probably will on our own. But
not that it wouldn't be a very joyful, fulfilling experience.
How is not people not going to do this?
I think it would. I mean, well, it's great, but it's not as good as talking about workers' comp.
Workers' comp, yes.
That is a good time, but it's got more of a party flavor to it than employment law.
Does it?
Yeah, I think so. less of an academic joy and more of a, woohoo, workers' comp,
The one thing we will do, the questions we didn't get to, is we'll import these frequently asked questions that we didn't get to into the ebook. Mm-hmm. So they'll be available on the ebook on sullivanattorneys.com.
That's great. Yeah, we have whole sections in there and just frequently asked questions. So
yep.
Again, read the book, man. It's in there. And if it isn't, send us an email.
Send us some questions.
Mm-hmm. Yep. Or comments again as to what we can do better or worse or whatever you want to say. But we are out of time. So I'm going to go ahead and thank you, Eric, for your
Thank you, sir.
Today. And as always, your commentary, and it's been insightful and helpful.
Thank you, buddy.
And thanks to the audience for listening.
Thanks, you guys.
Out our book and our webinars. And with that, I'll bid you adieu until next week when we'll have new and exciting things for you to listen to.